one Denny once where the whole thing was they had an identical twin.
Wasn't me.
Oh,
Well, I've heard of that case.
I didn't have, that's not mine.
yeah.
All right. We will call the case 26 CF 10, State of Wisconsin versus Stephen Ronning. The state appears through District Attorney Kevin Schmidt in person. Mr. Ronning appears in person in custody with his counsel, James McLaughlin. We're set today in this matter for a plea and sentencing. The parties have reached an agreement. Mr. McLaughlin, can you recite it for the record?
Yes, you're right. My understanding is that Mr. Ronning will be pleading guilty to count 1 in the information, operating a motor vehicle while under the influence, 7th, 8th, or 9th offense. Count 2 will be dismissed and read in for sentencing purposes. My understanding is that both parties will be making the same recommendation that the defendant be sentenced to 3 years incarceration in the Wisconsin State Prison System, but the sentence with any resulting extended supervision. The defendant, this sentence is recommended to the court to be run concurrent with his existing Minnesota sentence that he's serving in Olmsted County, or sentence out of Olmsted County. He's currently has been transferred here from the Minnesota prison system. Further, Your Honor, I did not discuss this raise this explicit ration. The defense did submit a sentencing memorandum by my client service specialist, Miranda McClevey, on Mr. Ronning's behalf.
Yep, it's red, it's marked.
Thank you.
What do you mean by extended supervision program?
If he has to serve any part of his sentence in the Wisconsin system and becomes earned release eligible, if there is any balance of his sentence that's less to be served, it would be converted to extended supervision.
You mean ERPSAP, right?
Yes.
Okay. Sorry.
That's what I mean by that.
But if and only if he sat completely day for day, the mandatory minimum.
Correct.
Okay. I have in front of me, Mr. Ronning, a plea questionnaire waiver of rights form along with the jury instructions as it relates to this offense. Did your attorney go over these documents with you?
Yes, he did.
Did he go over them essentially word for word with you?
Notice how the judge is being incredibly meticulous here. This is called a plea colloquy. She's building a bulletproof record to ensure Ronning can't later claim he didn't understand his rights or was coerced into pleading guilty, which is a common ground for appeals.
Yes.
And do you understand it completely?
Yes, I do.
And did you sign the second page of that document?
I did, yes.
So you're telling the court you fully understand everything that's contained on this plea questionnaire as well as the jury instructions.
Yes.
You're pleading guilty to an OWI 7, 8, or 9. You're 58 years old. You have 11 years of schooling. You can read, write, and you understand the English language. No drugs. Do you understand them completely?
Yes.
Do you need me to go over these rights with you in any more detail?
No.
So you understand them completely.
Yes.
Do you understand that by pleading guilty, you are waiving and giving up these rights?
Yes.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes.
Do you understand that you're pleading guilty to a felony? As such, you will no longer be able to use or possess a firearm for life.
Yes.
You will no longer be able to vote in any election until your civil rights are restored.
Yes.
Do you understand that the state would have to prove for operating a motor vehicle while under the influence 7th, 8th, or 9th offense on or around October 25th, 2025 in Burnett County, Wisconsin, you operated a motor vehicle while under the influence of an intoxicant? That is a Class F felony. Do you understand what the state would have to prove?
Yes.
You understand the maximum possible penalty could be a fine of up to $25,000 or 12 years and 6 months of incarceration or both.
Yes.
And pardon me, Your Honor, but the record can reflect, as the court was reading it, a copy of the information reciting that count 1 is directly in front of the defendant.
Thank you, Mr. McLaughlin. There's a mandatory sentence that the court shall impose, a bifurcated sentence under Wisconsin law, with a confinement portion of that sentence being imposed on you for not less than 3 years. Do you understand that?
Yes.
So there's a minimum mandatory sentence of 3 years of initial confinement in prison, or a maximum of up to 12 and a half years. But that would only mean an additional 7.5 years of initial confinement. So 3 years mandatory, 7.5 initial, with 5 years of extended supervision. That's mandatory in the minute, and the mandatory minimum as well as the maximum. Do you understand that?
Yes.
Now, do you understand that if I thought it was warranted based upon the facts of this case, your history, all of the things taken together, that I should sentence you to a maximum possible penalty or any other sentence? Do you understand it's my decision to do so?
Yes.
Do you still wish to proceed and enter a guilty plea?
Yes.
Did you go over the criminal complaint with your attorney?
I did. Yes.
In particular, that section that's called the probable cause section, where it basically says what happened and why you were charged with these crimes. Do you remember that?
Yes.
For the most,
Issue of odor of intoxicants, evidence of impaired appearance and as well as impaired driving. And in fairness to Mr. Ronning, he admitted that all of these facts were true. So therefore, Your Honor, pursuant to stipulation and review, there is more than sufficient factual basis within the narrative report to provide a basis for the charge as well as adjudication.
thank you. Has anyone made any threats or any promises to you, Mr. Ronning, for you to plead guilty today?
No.
You're doing so freely and intelligently. That means you're telling the court you fully understand what you're doing today
Yes.
and voluntarily.
Yes.
Has your attorney represented you competently?
Yes.
Has he done a good job?
Yes.
Has he looked at this matter thoroughly?
Yes.
Has he discussed with you the evidence and the discovery in the case?
Yes.
Has he discussed with you any potential legal defenses or a lack of defenses in this case?
Yes.
And it's your decision to accept a plea and not proceed to trial. Is that correct?
Yes.
This is where the judge checks on the competency of the legal representation. By asking Ronning if he's satisfied with his lawyer, she's effectively closing the door on any future ineffective assistance of counsel claims. It's a standard but vital procedural safeguard.
Are you satisfied with your attorney's services?
Yes.
Do you have any questions for the court or for your attorney before I proceed?
No.
As to count 1, operating a motor vehicle while under the influence, 7th, 8th, or 9th offense, how do you wish to plead?
Guilty.
The court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find you understand your constitutional rights and what it means to waive.
To other states, and part of my argument for why the court should do the 3 and 3 out concurrent to Minnesota has to do with that. So I'll start with that. Mr. Running's criminal history shows he did 2 burglaries in the 80s, and then the rest of his history is drunk driving offenses and then various low-level misdemeanor offenses as follows. 1986, burglary, Wood County, Wisconsin. 1987, burglary, Douglas County, Wisconsin. 1996, disorderly conduct, Douglas County. 2002, Douglas County, operation after revocation. 2008, Douglas County, battery. Then in South Dakota, 1994, Yankton, drunk driving. 1994, Yankton, insufficient funds for a check in the 3rd degree. 1995, Yankton, simple assault. Minnesota, 2001, St. Louis, drunk driving. 2003, St. Louis, drunk driving. 2006, St. Louis, drunk driving. 2011, Crow Wing, drunk driving. 2016, Renville, drunk driving. And now 2025, Olmsted, drunk driving. So basically what his record shows is that from 2016 until our case, he had no drunk driving offenses, showing a 10-year period where he was staying clear of it. Then he got the drunk driving offense here, where because of the nature of his criminal history and driving record being multi-state and mostly old, law enforcement misread it. There's like a fraction, a very small one after that. So I think if the court follows this agreement, the end result is his sentence is going to be a little longer, and it might affect his eligibility for programming through Minnesota. I think running it concurrent also enables Minnesota us to send him back to Minnesota and Minnesota shoulder the better programming. I think the criminal history reflects that he has a much stronger connection to Minnesota and a much more recent connection to Minnesota than here. I understand the sentencing memorandum shows that he has had connection to Wisconsin, but I think it's highly relevant that the vast majority of his convictions for drunk driving are Minnesota, almost all of them, actually. So for those reasons, the state would ask that you follow the agreement. Thank you.
All right, thank you, Mr. McLaughlin.
My remarks are essentially consistent with Mr. Schmidt's, Your Honor. I think the primary point is that in my dealings with Mr. Ronning, he's fully accepted responsibility. He never disputed the charge of the facts. He waived his preliminary hearing. He's accepted responsibility. He admitted to me he was operating under the influence. I believe he faces, as I believe my client service specialist memorandum details, he faces significant incarceration and in Minnesota, plus supervision until he's lost life opportunity and damage to his important relationships. And perhaps better late than never, but that he is coming at this late age in life, that he appears ready to want to change his behaviors and regain the balance of his life in a positive fashion. We in the legal system tend to call that aging out of the system, but really, I think it means it reflects a realization, either because of the pain of what you've inflicted on yourself and your family, that the punishment component of your conduct is set in, and that it is a external motivation to change. So, Your Honor, I think in terms of, I think Mr. Schmidt has, basically, he has these period of
The defense is referencing Gallion, a landmark Wisconsin case that requires judges to explain their sentencing objectives. It's not just about the crime. The judge must weigh the protection of the public, the gravity of the offense, and the defendant's specific rehabilitative needs.
On OWI-related offenses in the 90s, but then after that, essentially, it's a period of simply drunk driving offenses, not that they aren't serious, but there was a serious gap in terms of previous convictions until recent. So therefore, Your Honor, for these foregoing reasons, and under, of course, the court is well aware of McCleary v. State and Gallion, our seminal Wisconsin sentencing laws, that we use the least amount of incarceration consistent with the triad of the need to punish, his rehabilitative needs, and the seriousness of the offense. I believe the joint recommendation of the parties meet the McCleary and Gallion factors, Your Honor, when taken into consideration of the totality of his circumstances with his current Minnesota sentence. Therefore, Your Honor, for those reasons, I'd ask the court to please adopt the parties' joint recommendation.
Help work with my program. And that's about it.
He previously mentioned to counsel, Your Honor, that there is a Minnesota intensive treatment program that he was motivated to try to obtain before he came over here, or came back here to be specific.
I think that would be great if you do engage in something like that. And I told you, and I fully believe your attorney has told you that there is a mandatory minimum here, no early release, 3 years, mandatory. And you understand that?
Yes, I do.
And so if you're out early from Minnesota, but even if I figure the 46 months, let's just say you sit the full 46 months, but at 2/3, that would only be 2.5 years of incarceration. You would still need to come over to Wisconsin to serve the rest of your sentence. Do you understand that?
Yes.
Okay. All right. So, Mr. Ronning, I've read the memorandum. I've heard the arguments of both sides. I've heard your criminal history. You haven't had an OWI or DWI, as Minnesota calls it, since 2016, since you received ours. And then immediately thereafter, you received one in Olmsted, Minnesota. So 2 back-to-back. That makes it more serious. Had it only been 2016 until now, the 10-year gap, it could have been looked at as something different versus you were charged with this offense here, and then you were charged as the substance abuse order. You drink the alcohol, you drive. That's your problem. You drive. That's your problem. You drive. Now, have you had a substance abuse problem and you want to drink yourself until your liver fails? Good, great, grand. That's up to you. That's your choice. You get behind a wheel, you drive. That's your problem. That's a crime. And that's why we have 7, 8, or 9 and whatever you were charged with in Olmsted. It's extremely more serious. It's extremely more serious. We've had people with OW1s who have killed people, or OWI2s who have killed people or significantly injured somebody. You're just so super very lucky that no one was injured and no one was hurt. It's a weird thing that here in Wisconsin, our OWI first is a ticket, a forfeiture. That's it. It's just weird and not necessarily in the state's best interest. But that's where we are. But when you're getting up to these high offenses, it's not only more serious, it's absurd. It's crazy. We shouldn't even have to have people with OWIs this high. I do understand that you want to change, you're trying to change. You're 58 years old. You should have figured that out by now for a better path. And you have to, otherwise somebody could die.
This is a pivotal moment where the judge exerts her independence. Just because the prosecution and defense agree on a deal doesn't mean the judge has to follow it. She's signaling that his decision to drive drunk in 2 different states on 2 different dates deserves separate punishments.
Agreement does make sense. And I understand the reasoning behind it. You are accepting responsibility right away, but you don't want to be punished more. You want the good old deal of serving the times together. But they're 2 separate incidents, 2 separate states, 2 separate dates, 2 separate times you drank intoxicating beverages beyond the legal limit and put people at risk. 2 separate, all the things. So I just can't see that this is something that should be sat concurrently. But I don't know if it matters if I do it concurrent. You're going to be able to get out of Minnesota early with some types of programs, but again, you're not getting out. You're going to come to Wisconsin, you're going to sit your time, you're going to have a sentence. So you want to get out of Minnesota prison earlier, that's fine, but you're going to head on over to Wisconsin prison. With regards to this matter, the court does believe it is far more serious than 3 years in, 3 years out, concurrent. So what the court is going to do is I'm going to sentence you to 4 fines and fees plus a $10 blood draw fee. And even then you're getting the benefit of the doubt. I'm only using the fines and fees for the 4th offense. Simply because I'm going to tell you it's so hard to calculate and you're not going to pay it anyway. My gut's telling me that you don't have the money to pay it off anyway. The court is going to order, while incarcerated, you must make payments and it will be collected as a percentage from the Department of Corrections to be determined as reasonable by them while you are in prison and on extended supervision. They will collect these funds. This is a felony, no use or possession of a firearm for life, no voting in any election until your civil rights are restored. The court is going to order absolute sobriety, no use or possession of any illegal drugs, substances, or paraphernalia. no alcohol, no bars, taverns, liquor stores, casinos, or any establishment that has the primary purpose. And I'm ordering an alcohol and other drug assessment and to follow all recommendations. You cannot be released from any supervision until all of those recommendations are complete. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. The court is going to order that if you fail to pay your fines and fees, not only will a civil judgment be entered against you, you're always going to owe it, but the court will issue a warrant and you could sit up to 6 months in jail. I need to order your DNA. The jail will make sure that we have that. This is not a crime in which you can have your DNA expunged. I think that covers everything, Mr. Schmidt.
Did the court make a finding on eligibility for SAP or ERP?
The court will make you eligible for early incarceration only after it has been shown that you have had 3 complete and full years in custody.
Sentence credit is usually given for time already served in jail awaiting trial. However, because he was already serving a separate sentence in Minnesota, he doesn't get double credit. This effectively extends his total time behind bars, ensuring he doesn't just wash out his Wisconsin time while sitting in another state.
No release earlier than that. And that can be calculated using time in Minnesota, including time in Wisconsin. But you must sit 3 full years before you're eligible for any earned release programming.
Second, is the court ordering it concurrent or consecutive?
I said concurrent.
Third, did the court order a revocation of his license?
The court will revoke, oh yeah, I haven't gotten to that. 3 years of revocation of driver's license, 3 years of ignition interlock device. Holy guacamole. I can't believe that that has even ever been part of, should be a whole lot more than that. But your license most likely is going to be revoked from the Department of Motor Vehicles, the DMV. They'll figure that out. What else?
That's all from me.
Mr. McLaughlin.
Your Honor, I just want the court to make the finding, as I believe you already have, that because Mr. Ronning was under an existing executed Minnesota sentence at the time, that he therefore is not entitled to sentence credit in this case, and that's a part of our record.
That there's no sentence credit for here?
Yes.
Yes, there's no sentence credit for here.
And therefore, Your Honor, because the court has, Mr. Ronning understands that you've gone above the joint recommendation, but because you have recommended it concurrent, Mr. Ronning has told me, has given me authority to say that he is not at this time dissatisfied with the court's ruling. However, and I appreciate his accepting that. I think that shows again his acceptance of responsibility. However, he has 20 days from today's date to change his mind. Should he do so, he has the right to, within that time period, to seek relief to the Wisconsin Intermediate Court of Appeals services of his